Writing a brief is about more than informing the court of the facts and the law. That's a given. A successful brief has to persuade. It should present the information in a way that makes the court want to rule in your favor, and that makes it seem like the outcome you're urging is the right result. This course will cover tips and strategies for how to achieve that. The first one is to use the right tone. This is a big one because it'll affect how you write the entire brief. Let's think about how tone differs depending on who you're writing for. When you're writing a client memo, the goal is to inform and predict, to lay out the possible outcomes of an action the client is considering taking. The tone is objective. For example, if your client is considering moving to consolidate two cases, you might say, "A court is more likely to be persuaded if we can show that consolidation would serve the interest of judicial economy. On the other hand, factors such as lawyer convenience are less likely to be dispositive." The language here was even-handed. It objectively evaluated the potential outcomes. Now let's consider writing for opposing counsel. This time the goal is to show the other side why their position is wrong. The tone is assertive. On the same question of consolidation, you might say something like this: "The court is sure to grant a motion for consolidation. Setting aside that factors such as convenience and cost are easily satisfied, we will demonstrate for the court that judicial economy is unquestionably served by consolidation." That language was more decisive. It asserted what the outcome would be, dismissing other possibilities. When writing a brief to the court, your goal is to show the outcome you want is correct and just. The tone is confident and respectful. You want to show you believe in your assertions while still maintaining a deferential attitude toward the court. The brief might say, "Here, each of the factors is met. Consolidation would serve the interest of judicial economy because of the substantial overlap between the two disputes." Notice that this language is confident, but rather than asserting the outcome as decisively as you would to opposing counsel, it persuades the court by arguing that the relevant standard is met. Avoid hyperbole. Using exaggerated language throughout a brief is a common mistake. For example, "This argument is entirely frivolous and utterly without merit. It grievously misstates the law." Language like this comes across as overdramatic and often insincere. It weakens your arguments. Instead, show, don't tell. If the argument is frivolous, demonstrate that by explaining the argument's flaws clearly and logically. And when you do want to use a descriptive word for emphasis, be selective about when and where. A good rule of thumb is to include only one embellishing word in a paragraph, max. Come up with a theme that tells a story. Part of being persuasive is making the reader care about what you're saying. A key to doing this is to create a theme and weave it throughout the brief. You want to present the facts in an engaging story that makes your client sympathetic and relatable. Say the plaintiff was removed as CEO from the company she founded, and the issue in the case is a straightforward and dry contract interpretation question. You can make it more interesting by explaining the human element, that a young entrepreneur made the mistake of partnering with an industry giant. You could say she was unceremoniously ejected without warning and use words like ousted and blindsided. This makes the facts more interesting for the reader and sets the narrative about a sympathetic plaintiff who was wronged. A good theme shows the court why your client winning is the just outcome. Some examples are lack of corporate responsibility or a plaintiff seeking a windfall from a court judgment. It's also helpful to think about what theme the other side might use in their brief. You might be able to contradict their story by emphasizing a certain fact or undermine their theory with a competing narrative. Limit discussions of a case to what the court needs to know. Long, detailed case discussions take up space and are rarely useful. The court is left wondering what the point of the discussion was. One or two sentences discussing a case is usually enough. The only reason for a longer discussion is if the case is controlling law and clearly on point, or if the other side relies on it heavily. To keep your discussion short, think through exactly why you're citing the case, and then cut out all the other detail. If you need to add extra information, put in a short parenthetical rather than more sentences. Take a look at this example. Unlike here, in Denker, the court found there were credible allegations that board members placed their interests ahead of shareholders. Complaint pled self-dealing through numerous specifically pled allegations. The first sentence sets out the language from this case that's helpful to your argument. Then, the parenthetical adds the specific facts that the court relied on. Don't let the other side's argument take over your brief. Whether you're writing the opening brief or opposing one, you of course want to respond to the other side's arguments or potential arguments, but it's important to proactively make your argument too. Don't spend too much of your brief on the defensive, reacting to their arguments. This goes to the overall structure of the brief as well as to individual points. For big picture structure, you'll want to set up the argument in the order that features your strongest arguments and presents them most logically from your perspective, even if the other side prioritizes the issues differently. If your order differs from theirs, draft headings and subheadings that make it easy for the court to find your responses to their arguments. For individual points, rather than start a paragraph with what the other side says, lead with your point of view, the affirmative argument you want to make on that point. Then you can address the counterpoint. Here's a good example. First, it states the affirmative argument you want to make. This court should find that a termination event occurred because effect and meaning must be given to every term of the contract. Then, it brings up the other side's view. Defendant may argue that its conduct amounted to a mere cancellation event, not a termination event. And then it gives the reasons that the court can discount that view. Yet that reading would contravene basic principles of contract interpretation by ignoring that the definition of termination event includes unauthorized use of the product. This way, the court sees your position as the one that needs to be contended with.